Okay, we'll begin the meeting. Would you take roll, John?
Commissioner Kesha?
Here.
Commissioner Eskovitz? Commissioner Eskovitz, are you still on the line?
I'm going to guess no.
Commissioner Wasserman?
Here.
Commissioner Nguyen?
Here.
Chair Remke?
Yes, but should we pause and see if we can get Commissioner Eskovitz back on the line?
I will send him an email right now. I just sent him an email.
Does it? And then we'll get started.
Commissioner Eskovitz?
Okay, well, he was there earlier. Hopefully he'll join us again, but we're going to
Yes,
get
I'm
started.
sorry. I'm on. I was on mute.
Oh, okay. Where you're like, here. All right, good. Glad you're here. Okay, before we get started, I just want to take a moment to update everyone on the status of one of our biggest priorities this year. Excuse me. And I'm pleased to announce that our proposed electronic filing system for Form 700 is officially in the budget. I'm sure my fellow commissioners will join me in thanking and congratulating staff who have worked so hard on this project, getting it through the Department of Technology as well as the budget process. So their work has made this possible. And as you know, this is really a huge step for the commission in moving forward. And so we're really proud of staff. Thank you to everyone who worked on this, and that's many of you in this room. As we go forward, the next big steps are waiting for the budget final bill to be passed, and then hiring the project team, which are crucial steps. But we're on schedule, and I think there's no reason to believe that we'll have the 25,000 individuals that file Form 700s directly with the commission electronically file their forms for the 2017 filing season. Somewhat of an aggressive timeline, but I believe we can do it, and we're committed to making it happen. So again, this is really a victory for the commission. We know the current system is cumbersome for everyone involved, and we think this is a giant step forward in transparency and efficiency for the commission. Yes, Commissioner Nguyen?
Thank you, staff. Great job. And thanks, Jody, for your leadership. One question. So the 25,000 who file directly with the FPPC will be filing electronically. How many other filers are there, and what happens to their forms?
Well, as you know, the estimates are 500,000 to 800,000 other filers throughout the state who file with their local filing officer. Now, there are other state agencies that down the road may opt in to filing with us, and that's an option we want to keep open. I mean, I think there's clear benefit to having one centralized system. But again, right now we're focusing on those 25,000, which include about 5,000 to 6,000, as you know, that we post on our website, which is also a very time-consuming and tedious task under our current outdated technology. So those also will be immediate. Again, there'll be searchable forms. So this is really just a huge change in the information and sharing of that information. Anything else? Okay, thank you. Before we get started, item one, a public comment. Is there any public comment for something that is not listed on the agenda? Okay, I do not see any, so we'll move on to item two, which is approval of the April 2015 committee meeting minutes. Are there any comments or corrections before we vote to approve those minutes? Okay, I move to approve the April 2015 minutes.
Commissioner Kasher,
Yes.
Commissioner Eskovitz,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Remke.
Yes.
This motion passes.
Okay. Now, as for items 3 through 21, the proposed consent calendar. Before we get started, do the commissioners have any items they would like to take off consent? I'm going to take item 3 off. Any others?
I don't want to pull anything off, but I do have a comment on the consent calendar. So whenever that's appropriate.
Right. Okay. Any others that need to come off?
I just have comment.
Okay. All right. Then, and I believe Galena West.
I
our
also have a
acting-
comment.
Yeah, our acting chief enforcement has comments. And I think you're going to start off with giving us an overview on some items on the consent, correct?
I am Galena West, Acting Enforcement Chief, and I'd like to bring your attention to the San Bernardino County items. This is, as you know, part of the contract with San Bernardino, and these are the bulk of the cases that you're going to see. I just want to give you an overview of what we did. We worked with San Bernardino with technical assistance, legal division, and enforcement as a team to provide them advice, training, and then also audits of every candidate that was up for election in the county of San Bernardino in 2012. And so as a result of that, there were 22 cases. And you have the fine 5 to 6 cases, depending if you count Streamline, today. And then there were 3 warning letters, 9 no action closure letters, and we have 4 that are still pending where the audits went a little more time, or there's one that falls under the new Streamline program, assuming it goes well today. And so that's what I wanted to say. And then I also wanted to thank the staff that was heavily involved. The Technical Assistance Division, Dixie Howard, was heavily involved with this, Brian Lau in the Legal Division. And then in my division, the program specialists really took the time to not only do the audits, but educate, because as you can see, there are a lot of cash contributions in San Bernardino, and they're very surprised that there was a rule against cash contributions. So it was a very much of an educational procedure that went on, and that's Sony Manjet, Grant Beecham, Luz Bonetti. They did the bulk of the work in the auditing and education and enforcement's time with the people in San Bernardino. And then Zach Norton, I wanted to give him some credit for putting all these cases together. So I just wanted to let you know how that went, and you'll see those last 4 cases in the next month or 2.
Great. Thank you. So overall, I know there's a report from the bill which gave us this authority. When does that do? 2017? Is that right?
Yeah, I think so.
I think, yeah.
That's Hyla's problem. That's yeah, yes, I believe so.
Okay.
No, that's
But before 2017, you're giving a general positive
We are.
result. Okay.
And then what we're going to do proactively here on out is technical assistance, legal division, and enforcement are going to have a meeting and talk about what we learned from the first contract, facilitating the first contract, what we can do differently, how we can better use resources at the commission level. And Linda and I have spoken about doing joint training down in San Bernardino. So I know that was something that has also come up, and we want to do selective training there.
Great. Okay. Thank you.
I comment on the same topic.
Okay, go ahead.
Yeah, I see this as an opportunity to continue the education process for San Bernardino, because we have numerous web resources, in-person trainings, etc. But it sort of starts here, get some training, then we have enforcement and audit, get those results, and really it's a wake-up call to say, hey, and that may make it a little easier for us to do further training and further education, as people say, wow, there was stuff to learn that we didn't pick up the first time. So I see it as a good opportunity to, because the cases we have here, as we've mentioned, they're kind of some of the things that become, if you're familiar with what's going on, the basics.
Mm-hmm.
And they cover a range from the unsuccessful candidates who may be first timers to folks who have been around for some time. So it really says we need to really get in there, and hopefully now that they will get a second look at it, I got to hit the books some more. So it's an opportunity.
I agree.
Commissioner Wynn?
Thanks so much. Thanks, Glenn. Mike, that was my comment too. I see this as just a real nice success story. We were invited in, we were able to identify some problems, got some nice stipulations. So I really just want to applaud the staff on doing a great job on that pilot.
Thank you.
Thanks. Okay, if there's nothing else on that, do the commissioners have comments or questions on any other items on consent? Commissioner Wasserman?
Thank you, Madam Chair. Just a general comment that I guess applies to items 5, 8, 16, and 19, and just overall. I know that the Commission,
I'm sorry, which I didn't hear which
5, 8, 16, and 19, and it may apply to others, but it has to do with how we approach determination of number of counts versus violations, because we often have, say, four articulable violations that end up being in 2 counts in the process of getting to a stipulated settlement. And as I've said before, I am aware that it's a stipulated settlement, and 6 of one, half dozen the other. In other settings, it could be a settlement as to 1 count and dismissal of another, and we just sort of end up combining those. So rather than actually having a discussion about those individual ones, I just wanted to highlight it again because I think we've expressed that a sensitivity to the determination of when that should still be a separate count versus when it works in the public interest to stipulate out and combine them. So it's more of a general comment saying, hey, we're still aware of that, and I think we're all in agreement that we take it very seriously how those things are going to be addressed, and we'll address them if we disagree with the stipulated settlement.
Actually, that's a great point. In working with Chair Remke, one of the things that as acting chief I've been trying to take into consideration is the amount of information in the STIPs and exhibits that you receive. In fact, stealing my thunder in my Streamline presentation, but one of the reasons for the Streamline program revisions were to increase the amount of information included in the Streamline fines so that you would be more comfortable when you see a Streamline fine with the boxes all checked off and you understand that all those things were present or the things that weren't present. That's the same with the regular stipulations and exhibits. We're trying to include more information about the counts that are being combined or counts that for instance, a case that looks like it should have been streamlined, there might have been some other issues that created that committee to not fall into streamline. So we're trying to make sure that we put more information in the conclusions to lead you to a better understanding of what our thought process is.
Thank you. I think that's a great goal, and I think I definitely see the change in the stipulations, and I appreciate that. So thank you. Any other comments or questions on the consent items? Commissioners Kasher or Eskovitz?
Nothing for me. Nothing for me either.
Okay, is there any public comment for the items on the consent calendar, the remaining items 4 through 21? Okay, seeing none, I move, go ahead.
I move approval of the consent calendar items 4 through 21.
I'll second that.
Commissioner Kasher,
Yes.
Commissioner Eskovitz,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Remke.
Yes.
This motion passes.
So item 3, are we ready to move forward on? Okay, so item 3, are there any questions or comments? I pulled it because I believe we are wanting to verify information, including information that the statements of economic interest had in fact been filed.
Right, and I was just handed those statements of economic interest amendments, and so I think we can proceed to address this item.
Right, and this goes to that we want to make sure that everything is done as stated in the STIP, so I think there was an issue, but does anyone have any questions or comments regarding item 3?
Well, first of all, I'd like to, thank the staff for working up a nice stipulation. The one question I had was on page 6 of the stipulation. It says the media was questioning whether the land trade was an over the limit gift. So I saw it several times, in newspaper accounts on this, and I think we also got a comment letter on it. So I know that you looked at it, but I was just hoping maybe just for the record, we could talk a little bit about the gift analysis and why it was not included in this.
Okay, yes. Normally, we don't include the analysis for the charges we don't include in the exhibits. So what Neil Bucknell did, the attorney on this case, which I thought was well done, was he referred to the advice letter that he used the commission advice to do the analysis, which is one of the things we relied upon. And he applied that to the facts and found what was reasonable and credible, and to find out if fair market value even exchange occurred, or if this was income or gifts. So the analysis was fully done. And we also worked with the Orange County DA's office on this case, and they also did an independent analysis. And then we came together and talked about our findings to make sure that we were concluding the same. And so we had multiple discussions and worked closely with them. And after doing our independent analysis, we each agreed.
Okay, any other comments from the commissioners or questions on item 3?
I was just going to comment on that. So the discussion with the prosecuting agency, and they're operating under a higher burden of proof as well when they're doing their analysis. So
Correct.
right. Okay.
Okay, is there any public comment for item 3? Okay, I don't see any. Is there a motion?
I move to approve item 3.
I'll second that.
Commissioner Kasher,
Yes.
Commissioner Eskovitz,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Nguyen,
Yes.
Chair Remke.
Yes.
This motion passes.
Okay, great. Thank you. And now, Ms. West, you are going to discuss item 22.
I didn't know if Hyla was in between my.
You're still
Maybe
on.
you guys want to break
It's
it
all
up a little
you.
bit, but
Do not leave the room.
okay. Good morning. So one of the items that enforcement is presenting today is the Streamline Program Review and Recommendations. And I just wanted to go over the 3 reasons. One of them I touched on earlier, which is in response to listening to the commission in the last year to 2 years, one of the issues that seemed to come up agenda after agenda was trying to obtain the correct amount of information on streamline cases. There seemed to always be some question, and I think that was based on the information was difficult for the commissioners and the public to find because they're based on various memos and commission guidance over the years and needed to be consolidated and placed into one comprehensive memo with examples to so everybody was on the same page. And then also we wanted to be more responsive to the different types of cases that we see. As you can see, it kind of has my personal bent in one sentence in there because I've always felt strongly that people trying to comply with the act and filing their statements and making a mistake shouldn't be fined significantly higher than people that haven't even made the effort to file their statements. And so to bring some equality to that, we propose in the streamline to have non-disclosure violations included as with non-filing violations. And then the other change would be the $50 fee, trying to get in front of the tsunami of cases that we're going to have in order to comply with the statutory requirement that we enforce the $50 recipient committee fee that SOS will be collecting to get their electronic system up and running.
Okay, well, I will just start off by saying, Galina, I think you did an excellent job on this, and this is a really well drafted proposal and very clear and straightforward to me. But do any of the commissioners have any comments or questions regarding the streamline proposal? Go ahead,
No, I would just second what you said. I mean, this was really clear, very easy to understand, and the graphs, of course, really made it, pop out. So thanks. And I think you came up with a good balance in terms of what you ought to include in the stipulation and keeping it streamlined. So thanks very much for your work on that.
Yeah, I greatly appreciate this as well. What you noted about sort of the question from the public or even from folks in the agency as to when we see one of these, why is case A in streamlined versus case B? And I think this goes a long way to making it clear inside and out, and that's very useful. I have one question, and that has to do with qualification for the streamlined program and the evidence of intent to conceal. When we say evidence, we're including reasonable inferences from the facts that are before us, such as, we have a highly sophisticated individual who has been involved in certain sorts of things, and I'm just wondering how we're going to treat that, because I know if someone's on the other side of that argument trying to get themselves in the streamlined program,
Right.
they're going to say, well, you don't have direct evidence, or something on that order. But I think my understanding of that is we're really looking at evidence in the broader sense under the different ways you can get to determining what would be evidence for this matter. Is that correct?
You're correct. And I tried to write the streamline memo, and Malad Delgio also helped with this memo, and I wanted to give him credit. But I tried to write it to where it was more in layman's terms or everyday speak. And that way, anybody that could pick up this memo would understand it. And so I used evidence in the lay term of any information regarding it.
Sure, and absolutely. My question really
Right.
is geared the other direction to the professionals who will look at this. Okay, how do I work with my filer, etc. But I really appreciate that. On the flip side of that, it's a short sentence without a whole lot of qualifiers and whatnot. Just look and say, okay,
Yes, they would be hard pressed to present to the commission a couple of sentences that lead to the conclusion of intent to conceal, and the commission would say, "Sure, that's not hard evidence." So I don't see a lot of the sophisticated parties making that argument, but I guess they can try.
always can. Thank you.
Okay, any other comments or questions from commissioners?
Yeah, this is Commissioner Castro. Galina and Malad, thank you for your work on this. I just want to echo the comments. Very clear and just easy to follow. And thanks for your work on this. I really enjoyed reading the memo. It was good.
Thank you.
Okay, we do have one comment letter in support. Is there any
Yes.
other? Is there any other public comment on item 22? Okay, do not see any. I move to approve item 22.
I'll second that.
Commissioner Kasher,
Yes.
Commissioner Eskovitz,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Nguyen,
Yes.
Chair Rumke.
Yes,
This motion passes.
great job.
Prepare
Thank you
for
very
the
much.
onslaught of streamlined cases.
Can't wait. They've all been on the back burner. Okay, next we have item 23, a conflict of interest regulation, making participating and influence. And I will note in the memo, it says this is the last conflict reg we will be seeing for a while.
Hopefully. That is great.
Oops, you
Yeah, pull it
working?
up. I think just pull it up.
Is it working now?
push the button.
Just push it.
There
Oh,
you-
there we go. Chairman and Commissioners, Brian Lau, Commission Counsel. I'm here to present revisions to the Act's conflict of interest provisions as noted, the final proposal under the ongoing conflict of interest streamlining project. Under the Act, an official shall not make, participate in making, or in any way attempt to use his official position to influence a governmental decision in which he knows or has reason to know he has a financial interest. Currently, 5 regulations define when an official is making, participating, or influencing a decision. The most significant of this proposal is consolidating these existing 5 regulations into single regulation 18704. For the most part, this consolidating these regulations is non-substantive in nature. It is merely removing redundant and unnecessary language. Substantively, the proposal does 2 things. First, the proposal adds an exception for consultant recommendations. This is actually derived from an existing advice letter that essentially allows a consultant to make additional recommendation that would require that the consultant would be paid a little bit more, as long as the agency is already contracted with the consultant to make those types of recommendations. It's very similar to the terms of negotiating your terms of your own employment, which is also a separate exception. Secondly, speaking of the terms of employment exception, we are proposing, since the agenda mailer, we are proposing some additional language there to clarify that the exception does not apply to a decision to appoint, hire, fire, promote, demote, or suspend, or set a salary for the official or member of the family. This is actually historically, the commission has never allowed an official to participate in these types of decisions. However, this prohibition was formerly located in the materiality standards for personal financial effect. And this proposal moves the prohibition to a more obvious location. With that, there's a couple technical cleanups. First, we are taking some disqualification and recusal rules that are existing and merging them into proposed regulation 18707. And second, we are taking existing definitions of consultant and public officials who manage public investments and renumbering that to 18700.3. I should note that in response to suggestions from League of Cities, staff has made several minor clarifying revisions since the agenda mailing that should be highlighted in your packets.
So
However-
everyone should, just so I'm clarified, everyone should have the regulations that say on the bottom, the date 5/18.
Correct, that's
Okay.
correct. However, staff is recommending against the proposed changes in the league's comment letter. Separately, I'd like to draw your attention to the end of 18700.3. There is a comment there that dawned on us yesterday is no longer applicable. Should have been removed earlier in the streamlining process. So we are recommending that to be deleted at this point. That's 18700.3, page 3.
Is that the Siegel comment? I have to.
Yes,
Yes.
that's the Siegel
Just
comment.
right at the bottom of the reg.
It speaks to defining when you are a public official, and that's no longer included within that same regulation anymore. So,
The wrong regulation.
Well, I was going to actually ask about, but I'll wait on.
okay. With that, I would urge the approval of the proposal, and I can answer any questions.
Okay, questions?
Well, to segue into that, I was looking at that the comment. I actually thought the comment would be useful in 18704 if folks are looking at the question of making, participating in making, or using or attempting to use official position to influence a government decision, that if they refer to 18704 when they're trying to figure out if they are making a decision, that would be helpful to have that Siegel comment there, because I don't have a sort of an empirical study as to it, but I have the sense that with the various nonprofits throughout the state, finance or training or whatever, it would be, I don't know, would it cause any harm to have it there?
I think it's located in there is a little bit misleading. I think if we were moving it anywhere, it would be into 18700, which provides the definition of public that defines public official at this point, and that's what it used to relate to. Moving it to making it's almost it's a little bit hiding the ball. I don't know that it's an obvious location for it.
Is it at that other location?
No, it's not. It has been removed at this point.
Okay.
I would
So you're right,
add-
that would be a better, I'm sorry.
Sorry, no. I'm strongly opposed to comments. I don't
Right.
understand how that works in making a regulation. I don't know how this process got started, but either you put something in a regulation or you
I would
have-
agree if we did do something, I would
But
move it
that's a-
into the actual.
That's a,
Right,
that's a
move it to the
personal
body.
issue. I don't understand the authority or meaning behind a comment, but I'll
Not-
just throw that out. I would encourage staff to, if there's a meaningful reason to have something, to make it part of the regulation.
And we are going to do that circle back on the conflicts reg. So maybe we're keeping a list of items, and then we can look at that. Possibly this could be.
If it becomes an issue, right,
Wanna add it
we
back.
will be coming back with cleanups over the next year or so, when we find them. So, I mean, it could be a consideration of something that we might want to add back to 18700, the definition of public official, if it becomes an issue.
Right. Yeah. Then since it's not, that regulation is not before us now, I agree that comment should be removed here, and that hopefully we can put it on the list for not inclusion as a comment, but perhaps a reference in the definition to allow those looking at the definition right off the bat to understand. Well, we'll come back to it, but just so that we can come back to it. I don't want to go through the whole thing at this time.
Yeah,
Thank
I
you.
think that's a good point. Any other comments or questions? Okay, I believe we have public comment. Mr. Mason, I know is here.
Yes, good morning. Thank you, Chair, and key members of the commission. Just a couple of comments. One, we do support staff's recommendations. We think that the structural changes that they're suggesting make a lot of sense and will improve the regulations. And we did address a couple of minor revision appears before. It seems legalese, lawyer language, and we suggested speaks as one minor refinement on the language. And then the other sort of the policy recommendation that we're making is that in the statute, if you're a member of the city council, you can't stay in the room when the city council is considering an item in which you have a financial interest. And we're suggesting so the legislature has determined that presence might influence the decision, or at least create the appearance that it might influence the decision, and drew that line.
On your own agency.
Correct.
Right.
And we think that sort of should be consistently applied. In fact, there might be even better reasons to apply that to a city council member going to a planning commission meeting and sitting in the audience, since typically they're the ones who appoint the planning commissioners. This planning commission is sort of a subordinate body to the city council. And so that was the thinking behind that recommendation. The only other thing is I have a question about, and perhaps a suggestion with respect to the terms of employment provision. Don't have any issue with the policy and what's being recommended, but I did want to make sure, because that's an exception, and there's an exception to the exception in the materiality standard about appointing yourself to vice mayor when you get an extra $50 a month for that, or a JPA, that type of thing. My understanding is that there's no intent to change that policy in doing this. And if that's the case, then perhaps cross-referencing that in the materiality reg might make sense. Those are my comments.
Thank you very much.
That
Are
is
there-
correct that we didn't change the materiality standard.
Okay, we didn't change it.
Or any of those exceptions within the materiality standards.
Okay, thank you. Are there any other public comments? Okay, seeing none. I'll move to adopt item, what are we on? 23.
Commissioner Kasher,
Yes.
Commissioner Eskovitz,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Remke.
Yes.
This motion passes.
Okay, at this time, we are on item 24, which is closed session. The commission will meet in closed session to discuss a pending litigation matter with its legal counsel, and we will be back after our closed session. Thank you.
I work for the Office of the President more indirectly. I was with the Education Abroad program. And I was an undergrad. I was part of the program. And they were under the wing of the Office of the President. We were in the lead of them. Yeah, I know. I think Scott is first. And then city attorney. I think that's what we working on.
Welcome to AT&T's teleconference service. Please enter your access code, followed by the pound sign. There are 2 participants on the call, including you. You are joining your conference as the host. For a menu of available commands, press *#.
May I ask who's on the line?
It's Sean Eskovitz.
Thank you, Commissioner.
Commissioner Cashner.
Well, I'm just gonna let the staff get this. Like that. Always. There's now stuff. Yeah. So, is it? It's not as. What's that? Yeah, my flight's Phoenix. This is my daughter's, my brother and I went to You too? Yeah, they were in San Jose Monday and Tuesday.
My cousin went to that.
Oh yeah?
Yeah.
They were in Vancouver, then San Jose, and I
Planned
Phoenix,
Roxy,
and then LA.
just like it's small.
Yeah, it's gonna be good. Yeah, I was asked to run the Rose Bowl. And then obviously right. Yeah, and I went. I was looking I mean, we're up in the upper.
That's still really good. Is that the normal price, or did you just get it?
I went through tickets, got it and stuff. And I just built so I kind of stuff. Yeah. No, I mean, we're up in the.
I would even know even more than that.
So I was reading that. They have the stage down front, but then they got the whole stage across the whole arena floor. And then the sound system, instead of all the speakers, they all the sound up on the roof. So the sound is going to be coming down. So I'm like, okay, if the sound's coming down, I'm actually closer to them. But
Yeah.
Section 212 instead of, you know. I did. It's probably not bad. And it's the old America West. It's a nice country. Yeah. Normally I would
You know how Bonner always wears blue glasses?
What's that?
You know how Bonner always wears blue glasses? When I was in London, like several times ago, they had billboards for U2 everywhere, and he didn't have glasses on. And I was like, oh my gosh, they don't see what the glasses was. They recognize.
You know why it was?
It's like,
You just paid
Really
$40.
sensitive. That's piece of it. You guys,
Yeah.
people are always asking why.
Oh, and everybody moved to the
I
side
had
because
friends that
I have to say.
were on a holiday, a trip, and they were thinking of Ireland. There was no one that could. He apparently owns a pub there or a restaurant or something. So we went to a thing, it was actually there.
Never happened.
Yeah, I mean, what are the odds? They walk in and he's like, they sat down at the bar and all of a sudden he walks like from out of the kitchen and stuff. And he's like, Bono?
No, we tried so much. Yeah.
Does it look like? Can we find him a drink? We just sat down, had a pint with him. I'm like, yeah, I'll have that. I'm bored. No, I'm looking forward to it. It's, yeah. That's just not. It was up in Beck.
Yeah.
I saw that. It felt like that. Whatever it should happen. Exactly.
Let's just clarify, everyone's here to take roll.
Commissioner Kasher and Eskovitz, are you still on the line?
Yes. Yes. Yes.
Okay, soft roll. Okay, we are reporting out of closed session. In October 2014, the commission issued a decision and order in a case against council member Stephen Dietrich. The enforcement action was a result of Mr. Dietrich's improper use of campaign funds to pay his son's legal fees. The case was resolved by a stipulation between Mr. Dietrich and the Enforcement Division, which was approved by the Commission, wherein Mr. Dietrich acknowledged he violated the Political Reform Act and agreed to a $3,500 fine, which he paid. That's longer. The maximum fine for the improper use of campaign funds is $5,000 per violation. In this case, the stipulation between the parties recommended a reduced fine because Mr. Dietrich represented that he had personally reimbursed his campaign committee for the improperly spent funds. Although the act does not require reimbursement, this fact was offered by Mr. Dietrich in mitigation. Some months later, the FPPC learned that the representation by Mr. Dietrich was false. He had not refunded the money. As a result of this misrepresentation, the Commission has thoroughly examined its options to determine whether there is any recourse against Mr. Dietrich. After consulting with our attorneys in the legal division and with the California Attorney General's office, the Commission has concluded there is no viable action to compel reimbursement or to seek other relief. Therefore, we are closing this matter. The Commission is putting internal proactive systems in place to make sure this situation does not happen again. Although it has always been the Enforcement Division's practice to review every material fact stated in a stipulation and an exhibit, we are adopting additional procedural safeguards to verify the information before a stipulation is presented to the Commission. In addition, the Commission will consider whether changes in our regulations or the Act are necessary to strengthen the laws on personal use violation and the remedies for those violations. That's it. Okay, we now are going to move on to item 25, which are the executive staff reports, and we do have an action. We're going to start with Suki.
Chair Remke and Commissioners, Suki Brar, Legislative Coordinator and Senior Commission Counsel. The legislative report does summarize the status of the current bills that affect the Political Reform Act pending in the legislature. AB 594 has passed out of the Assembly and is now on its way to the Senate. Staff has worked closely with the author's office on this bill. The bill would simplify the campaign reporting schedules by eliminating unnecessary and duplicative campaign reports. The bill would also simplify and clarify pre-election reporting requirements by making them uniform from year to year and easier to understand. Staff recommends the Commission take a support position on this bill today. And also, as noted in the staff report, a previous version of this bill increased committee qualification thresholds and other reporting thresholds. The Commission may also consider supporting the bill if amended back to the previous version today, which staff also supports.
Questions from the commissioners? Commissioner Wynn?
Thanks, Suki. As you know, I have an unusual interest in legislative, in the legislative proposals, and also feel like the FPPC ought to be in a position of taking positions because staff here are the experts and the Commission spends a lot of time talking about it. And I think we assist the legislature when we take positions. So I'm happy that you're proposing a support position. And I could really go either way on whether we ask that the thresholds provisions be reinstated. And, I would rely on my other commissioners to figure out whether that's should be the case. But I do thank you for bringing this forward, and I do support us taking a position.
I'll just state my position is that we definitely support it as is, but I would also encourage support if amended. I do believe, as stated in the memo, that raising the thresholds on just the entry level of what becomes a committee is important. It is one of those things, and the reason that there was a threshold to begin with was to encourage participation in the smaller campaigns. And we have heard, and I have personally heard, of individuals running for office, and the nightmare it becomes very quickly when they're just trying to do a small level race, often even for no pay. And if they become a committee, and all the requirements they fall under. So anyhow, I believe that is the right move, but I'm leaving it to hear from my other fellow commissioners as well. Any other comments?
Madam Chair, I'm in agreement. I'm sorry. Go ahead, Commissioner.
This is Commissioner Kasher. I'll just add that I do support us taking a position on the bill. I am not in favor of a proposed amendment, only because I think that I understand the interest in increasing the threshold, but from my position, it appears that by increasing the threshold, we will be, in a sense, getting fewer reports, and I think it kind of cuts against our policy of promoting transparency. I don't know how many campaign committees would be impacted by this change, and that was one of the questions that I had to see, what is the significance of this change. But I do support the proposed bill as it's written. I just would not support the amendment if the thresholds were changed.
Okay, I want to hear from others. I would just comment on that issue of we don't know how many would be impacted. I think one of the issues.
Oh, it's on, sorry.
One of the issues is that it discourages participation. So the issue is, are there people not even becoming a committee and not even getting in the race? Because at $1,000, we looked up some statistics, which I forgot to bring with me, but once you file a candidate statement and the filing fee, you can quickly become $1,000. Now, you don't count as a committee if you pay it out of pocket. So you're faced with this dilemma of paying roughly $1,000 out of pocket to run, or start to raise that money and become a committee. So to me, that's not really promoting and encouraging participation in the process. But again, that's my position. Commissioner Wasserman, did you have something?
Well, I was in agreement with the chair's comment about the balancing that's already within the act, such that an adjustment with the concerns that you've discussed is not not problematic for me. I mean, I just see there was a balancing, and the balancing needs to be recalibrated.
Yeah, this is Commissioner Cashner again. I'll just add that I think part of this is from my own practical experience. In my experience and the individuals who I've spoken to, there are several considerations that go into whether or not you want to participate in public service and run for office. In this, at least from conversations that I've had, is just not something that has served as a deterrent for the individuals who I've spoken to. And so I think part of it is just a point of reference, but that's kind of what's also informed my decision on this.
And so you're not in favor of the possible proposed amendments or seeking a motion if amended, or I'm just trying to get an understanding.
The way that I understand the existing bill,
You do support
it does not include the increased qualification thresholds. Is that correct?
Right.
I'd support that version of the bill.
Okay. Well, I think we have, I believe we're going to have some public comment on this issue. Is that correct? Okay. Let's hear, if there's any public comment, please come forward.
Madam Chair, Commissioners, Philip Ong on behalf of California Forward and the California Forward Action Fund. It's good to see all of you, tanned and rested. We come in support of AB 594, and in our support letter to Mr. Gordon, we did strongly urge him to return the provisions that adjusted the thresholds. We think that it's a good balance in both modernizing the act and also respects the fact that the act affects the most elite candidates from the state candidates down to those running for dog catcher down at the local level. And from a perspective of we think the commission's priorities, I'm not sure how many of the under 2,000 committees you're actually tracking. I think most of them will fall under streamlined enforcement anyways. And so, but we do understand the concern that that folks could spend up to a certain level without disclosure, but they never really fall under your regulatory or enforcement eye in the first place. Another thing we would point out is that this is a legislative recommendation that the FEC has been making to Congress for 3 straight years now. Now, we know that the FEC never agrees on anything, as we're seeing with our good friend, Ms. Rabel. But this is something that all 6 commissioners have agreed upon and made legislative recommendations to Congress. And so we think that we think this commission should make the same recommendation and support the modernization of the act by adjusting these levels. Every 2 years you adjust the contribution limits and the gift limit. I think it's okay to adjust the disclosure limit at least once every 3 decades. So, thank you.
Is that the last time, or is that when it was set in 30 years ago?
Some of them, yeah.
Yes.
Some of them are that old. Not all of them, but yeah.
Okay. All right.
So thank you, Mr. Ong. You actually made the point that I had been thinking about. These levels have not been changed for decades. And, when this was initially put into place, it was to really allow the very small, committees to move forward without burdensome filing requirements. So, but rather than propose a support if amended, I would suggest maybe a support with amendments. So we're supporting the bill regardless, but we are asking for the amendment. So I'm going to make a motion that we support the bill with amendments.
Okay.
All right. So rather than a motion to support it and a motion to support if amended, I'm going to make sure I understand what I'm going to be voting on.
Well, I don't want it to be, if you don't accept this amendments, we're not going to support your bill. So I want to say that we'll support your bill, and we're also suggesting the following amendments. Yes.
Both. Oh.
Are those 2 votes?
Is there a second?
I'm just trying to make sure we're voting correctly.
I think if I understand the motion correctly, maybe this would be the way to frame it, would be to say we support the bill and we support the proposed amendment.
I mean, that's Commissioner Wynn's motion that she's going to make.
Yes, that's exactly what I intended.
Oh, okay. I wasn't sure if you were stating you were going to make a motion or you had made the motion. So
I second that
If I-
motion.
Can I ask just one question? The motion as stated suggests that we would be willing to accept the bill with any proposed amendments, or are we limiting it to
The
this
amendments,
specific?
I'm sorry, the amendments in the staff report.
Okay.
Which would be the previous version of the bill. Nothing else other than that.
Any other questions? I had second the motion.
the previous version thresholds is all we're talking about, not
Right,
previous version.
that's all that was changed, yeah.
Sorry, we're really digging into it.
Commissioner Kasher?
I'm going to vote no because while I support the bill, I do not support the change in thresholds.
Commissioner Eskovitz?
Yes.
Commissioner Wasserman?
Yes.
Commissioner Wynn?
Yes.
Chair Remke?
Yes,
This motion passes.
thank you.
Thank you. Oh, sure.
Commissioner Wynn?
Thanks, Suki. I had just a couple of other bills that I thought maybe the commission ought to take a position on. The first was AB 910. And it, you know, we had the San Bernardino cases today up, and I think that's such a success story for us. It seems like we might want to continue that by allowing other counties to contract with us. And just wondering why we might not support that.
I'm sorry, is 910 still moving?
And 910 failed to pass
Okay.
the deadline to pass out of the first policy
Fair enough.
committee.
Okay. My second question goes to AB 1200. Gordon, that just seems like the kind of bill we might want to support, and I'm wondering if you've analyzed that.
We've taken a close look at it in the last couple of days. It just was recently amended. The newest version was available yesterday. So we looked at it, but we haven't had enough time to consider the position on that bill yet.
So could we bring that back in June? to
Sure.
take a look at?
I will add that, yes, that's a bill that's been brought up and discussed thoroughly. Staff has met with the, I guess I would call staffers of the bill. Is that fair to say?
Staffers and proponents.
Yeah, who are McGeorge students.
Yeah.
And the concern I have is, first of all, there has not been an articulated problem or loophole in existing law. And that, as we all know, once stepping into the procurement process, it becomes very complicated. And before we take a formal support position, I would like to get a better understanding from other agencies in the government who do handle procurement and what their concerns would be. I mean, it's already such a complicated system to get a contract with the state, and I think we need to be cautious about making it more complicated if we don't know what we're trying to get at or what issue we're trying to address that's not already addressed under our complicated procurement laws and even our lobbying requirements. So that's the concern I've raised, and again, I've not heard the answers to those issues.
No, I think that's great in any sort of thing. It's why are we doing this? And even if we have the power, or the legislature has the power to do it, should they? So, yeah.
But we will continue to monitor and give you more information at the next meeting and see where it goes. Any other questions or comments on the legislative report? Okay, thank you, Suki.
Okay, thank you.
Were there any other reports we were going to give? Okay, if there aren't any other comments or questions on the other executive staff reports, they'll be submitted. Okay, thank you. And I would move to adjourn.
Second.
Commissioner Kasher?
Yes.
Commissioner Eskovitz?
Yes.
Commissioner Wasserman?
Yes.
Commissioner Wynn?
Yes.
Chair Remke?
Yes, thank you.
Thanks.